So I'd like to welcome everybody to this seminar it's a joint seminar that we've brought to you by Garden Court Immigration Team and the Garden Court Youth Justice and Child Rights Team. We're focused today on children persistent offending as a bar to naturalisation and the liability for deportation and what might be otherwise described as exile. So our panelists today are from the Garden Court Immigration Team. We've got, as to start with, we have Greg O'Kelly and Helen Foote, who I'll introduce in full in a moment. And also we then have Dr. Tim Bateman, who's an academic from the University of Bedfordshire and the Children's and Young People's Centre for Justice Associate there. And I'll come to introduce everyone more formally in a moment and more fully. But whilst we're waiting, I just wanted to give everybody the outline of what we're going to do. We're going to hear presentations of about 15-20 minutes from each person, and then we will go to Q&A, and the instructions for that are in the chat. So the questions and answers should go into the Q&A, but the instructions for how to ask a question are in the chat at present. But I'd also like to welcome Kate Aubrey-Johnson, whose actual initiative from Garden Court Chambers, whose initiative this seminar was, and her concern, which is primarily aimed at criminal practitioners, but to clearly understand the implications of immigration and nationality issues that arise in these crossover practices. And we're aware that there was a gap there. So I'm going to hand over to Kate, and then I'm going to introduce each speaker as they come. Thank you.
Thank you, Sonali. Welcome everybody this evening. It's great to see such interest in this topic. And as Sonali says, this seminar came about because we have recently launched a youth justice and child rights team in Chambers. And one of the reasons we wanted to form that team is because we were aware, as a multidisciplinary Chambers, that we were able to use our collective knowledge to better represent children who come into contact with the justice system. And because we recognise that children who come into the justice system may not only have need for criminal legal advice, but there may be other issues in terms of their rights, their leaving care rights, other community care rights, housing issues, and of course, there may be immigration issues that arise from their criminal proceedings. And it became very obvious that criminal lawyers are not always aware of the immigration implications of a criminal conviction, and that might affect the legal advice that they are giving children in particular. And that might be around changing the way that they would be advising a child. For example, if a child was wanting to contest a case, which would, if convicted, result in the child receiving a custodial sentence, as compared to them receiving a non-custodial sentence, as you'll learn in a moment, has huge implications for whether they would be facing a deportation order, for example. So it may be in that regard, but it may also be around not allowing children to get that first criminal conviction, because as we also will learn in a moment, that childhood offending can have long-term consequences for them. And even though children can have lived most of their life in the UK and grow into adulthood, they may still face either a bar to their naturalisation or deportation proceedings as a result of offending as a child. And the converse of recognising that criminal lawyers may have much to learn from our immigration colleagues is also that we, as child rights and youth justice specialists, also know that childhood offending should be considered very different from adults who offend, and what we know about why children offend should inform what that would reflect in terms of their likelihood of future reoffending, and also whether or not they would be conducive to the public good. And I think that if immigration colleagues can also learn from that knowledge, and we are very lucky to have Tim Bateman with us, who is hugely knowledgeable around childhood offending, to inform the arguments that immigration lawyers can bring in terms of challenging deportation or bars to naturalisation. then that might also inform the case law, which, as we will learn, is regrettably very draconian in terms of the consequences for children as they go into adulthood. So it's a huge pleasure to be part of the seminar this evening, and I'm looking forward to being part of the discussion at the end so that we can grow together as a legal community and improve the way we represent children and adults. Thank you.
Thanks very much, Kate. That was a great introduction, and it again emphasises the multidisciplinary nature of our garden court practice and why it's so important that we all work together on this. So I'd like to first of all introduce Helen Foote. I'm sure she's well known to many of you, particularly those who practice in immigration, but for those who don't, Helen is a very experienced junior barrister doing immigration, public law and human rights and nationality. She's got particular experience as an advocate in the tribunals and the administrative court, and as I've had the pleasure of appearing with Helen in the Court of Appeal and the Supreme Court in some of the lead cases on deportation and nationality. Her judicial review practice, she also operates in that field, doing immigration detention, removal and deportation, of course, and certification of protection claims, and also a significant practice in relating to victims of trafficking and modern slavery. Helen also acts in civil claims against public authorities in the immigration context, including false imprisonment and Human Rights Act damages cases. But for today, Helen's going to be talking about deportation and liability, and how children end up in that situation in the statutory context. So thank you very much, Helen.
Thank you, Sonali and Kate. I'm just going to share my screen now and bring up my slides, so hopefully this will work. There we go. Okay, so I'm going to be looking at two ways in which offending during childhood can have future consequences in immigration terms. First of all, deportation, which has been touched on in the introduction, and then naturalisation as a British citizen. So that is one way of getting British citizenship based, in essence, on having lived here for a sufficiently long time. And I should probably just say at the very beginning that all of the provisions we're going to look at, which are really quite draconian provisions in relation to deportation, and I'll explain in a minute what exactly deportation is, all of those measures only apply to non-British citizens. And so having citizenship is really key. And there is and again, before I started, you may be aware of something called the PRC-BC. So that's the Project for the Registration of Children as British Citizens. They do really important work in terms of assisting children and their representatives in registering children as British citizens. I'm mostly going to look at future naturalisation when people are adults, but it is worth having a look at PRC-BC's resources. They're the organisation who've got a test case in the Supreme Court, I think on June, looking at the fees that apply for children's citizenship applications. It's a different issue I'm not going to talk about, but I just wanted to flag the importance of being a British citizen, because all of the horrible consequences I'm going to talk about only apply to non-British citizens, so that's deportation. So first of all, what is deportation? Because often deportation is used in everyday language just to mean forcible removal, so for putting somebody on a plane and sending them back to their home country. What deportation is, it's a term of art really in immigration law, and it's a particularly draconian sort of subcategory of forced removal. And the reason it's very harsh, apart from the fact that, as we'll see, the categories of persons who are looked to deportation is very broad, deportation operates by default as a permanent ban on re-entry to the UK. It's possible to re-enter, but only if a deportation order is revoked, and the presumption is that a deportation order isn't revoked for at least 10 years, where the sentence of imprisonment imposed is more than 4 years, less than 4 years, and it's an indefinite re-entry ban for sentences of at least 4 years, and unless certain exceptions apply, including that the refusal of revocation would be a breach of human rights. So that is what deportation is, broadly speaking, and the Secretary of State's power to deport comes from the Immigration Act 1971. There are two powers there, the key power being the power under Section 3, subsection 5, and that enables the Secretary of State to deport somebody if she thinks that his or her deportation would be conducive to the public good. Most deportation cases involve criminality, criminal offences, and occasionally we do see cases that involve very serious non-criminal conduct, but really deportation case law is all about criminal offending. There's another power in Section 3, that's the power under subsection 6, which you may have heard of, which is where a court can recommend deportation where somebody has attained the age of 17. So we can see there that applies to 17 and 18-year-olds and adults. And so that's the other power under Section 3 of the 1971 Act. So in addition to that general power, there have been all sorts of legislative changes increasingly over time, which really widen the category of people who are liable to deportation and make it even more difficult to resist deportation. The first one that's worth knowing about is the UK Borders Act 2007. That introduced the idea of automatic deportation. That doesn't mean that you necessarily are ultimately deported, but it does mean that you can only prevent deportation if one of the exceptions in the statute applies. So that's an automatic presumption of deportation where a person is a foreign criminal, and criminal is defined there as a person who is not a British citizen who's been sentenced to a period of imprisonment of at least 12 months. So that is the definition of a foreign criminal in that act, and that is why a sentence of imprisonment of at least 12 months is significant, although as we'll see in a moment, it's not necessary, it's not sufficient or necessary to have a 12-month sentence in order to be liable to deportation. Importantly as well, period of imprisonment of at least 12 months in that statutory context includes a reference to a person who's been sentenced to a period of detention, including in hospital and in a young offenders institution. So we can see how in that way youth offending to deportation. So as I said just now, you don't have to have been sentenced to at least 12 months in order to be deported. I'm just going to pause for a moment because I think there are some technical difficulties with hearing me. Apologies.
I think it's largely okay, Helen, so carry on.
Okay, I'm sorry about this, everybody. I'll try my best. So we also then have and it's a very complicated statutory regime, even if you're an immigration practitioner. But broadly speaking, from 2014, when Theresa May introduced the Immigration Act 2014, a new statutory regime was introduced whereby courts and tribunals are given a formula whereby they are to decide whether or not deporting breach of Article 8 or not. And the definition of a foreign criminal for those purposes, so these are the people for whom this Article 8 code applies, includes not just people who've been sentenced for more than 12 months, but also people who've been convicted of an offence that's caused serious harm, or people who are, quotes, persistent offenders. So typically cases involving persistent offending involve people who have a long string of very minor or petty offences, often increasing in their seriousness over time, and very often involving offences committed when the person in question was a child, sometimes in the context of being groomed or involved in criminal gangs. There's a case that, there are two cases actually, which define what a persistent offender is, if you're interested. So those are the cases of Bimbuga and SC Zimbabwe. And in essence, a persistent offender is someone who keeps on breaking the law, and courts and tribunals have to look at the whole history and pattern of offending to decide whether or not that person indeed is or isn't a persistent offender. And it's only if they are that they will be subject to this quite strict regime, which tells the courts whether or not, or gives a formula for the courts to decide whether or not their Article 8 rights are breached or not. Because very commonly the deportation cases that we are involved with in the tribunals involve Article 8 rights. Sometimes Article 3 rights and refugee convention claims, but quite typically Article 8. But of course, as Greg's going to talk about in a moment, even though you can be caught by this regime on the basis of offending which took place when you were a child, the fact that it did occur when you were a child, or the fact that you've been, in the words of some of the case law, a homegrown criminal, i.e. somebody who's been in the UK for a very long time and first arrived as a child or was born here, that will still be relevant to the merits of your appeal. But it's important, I think, just to take away that you can have a series of fairly minor offences, which if you're a criminal practitioner, you understandably don't regard as very serious because you deal with much more serious offending. In the context of immigration law, it's really quite draconian and really quite petty offending can be subject to the deportation regime. So that is deportation. The next thing I wanted to look at a little bit more briefly is another consequence of childhood offending, and that is the good character requirement for naturalisation as a British citizen. So naturalisation is one way of acquiring citizenship. You can naturalise as a child, although there are other routes to registering as a child, and that is the work that the PRC-BC is focused on. But I'm looking here at naturalisation as a British citizen, which requires you to meet various statutory, definitely to remain, not being outside the UK for more than a certain period of time, and so on. But importantly, also requires you as an applicant to be of good character. That isn't defined in the statute, but it is set out in some detail in an increasingly harsh and lengthy policy that's available on the Home Office website, which which I suggest you have a look at briefly. The latest version, it's updated very frequently. The latest version is dated the 30th of September last year, and you can find it on the Home Office website. And you can see from that guidance that good character doesn't just include criminality, but also includes non-criminal behaviour, factors such as whether or not somebody's financially sound, even things like parking fines, bankruptcy. A very wide range of behaviour can be taken into account. The good character requirement applies to all applicants aged 10 or over at the time of the application. And the guidance says, I won't read it out in full, but where children are concerned, it's important to take into account mitigation relevant to the child's particular circumstances. Where a child has been convicted of a criminal offence, sentencing guidelines require that any custodial or non-custodial sentence is adjusted to take into account the child's age and particular circumstance and mitigating factors. So in theory, that is a flexible starting point. Also, just as a headline point, the guidance includes a series of thresholds, not the same as the rehabilitation periods for the purposes of the Rehabilitation of Offenders Act, but a series of time periods within which a person is excluded from being naturalised following a criminal sentence. I haven't put the thresholds in there, but broadly speaking, for example, where somebody's been sentenced to imprisonment for a period of at least 4 years, the guidance says that an application will normally be refused for sentences between 12 months and 4 years. Duration is 15 years until somebody's, or the rule of thumb, normally the person won't be considered for naturalisation until at least 15 years, and so on down through the sentencing thresholds. For that does apply to detention and training orders, and the rule of thumb is that you look at the custodial period of the detention and training order. And in general, for those sentences, so non-custodial sentences, including DTOs, I think I'm right that the default period is 3 years. Normally, you've got to wait 3 years until you're eligible for naturalisation. But so that's another way in which childhood offending can be a real barrier to immigration status security. So in future applications for good character, but as I mentioned, for naturalisation, but as I mentioned, there is another route to citizenship for children, which I haven't considered here, but the PRC BC are quite active in looking at the issues around that. That's all I wanted to say. I hope there's time in the questions for discussion, and Greg is going to look in more detail at how some of the immigration case law plays out in terms of childhood offending.
That's great. Thanks very much, Helen. And we could hear you. There was just occasional going in and out, but I think everyone could hear you. And also we had the slides to look at that you were speaking to. So thanks very much. I'd like to introduce Greg O'Kelly, from another barrister from Garden Court Chambers, senior, junior, specialising in human rights, asylum, immigration and public law, being described in Chambers and partners as very, very effective and the Legal 500. He's got over a decade of immigration law experience. He acts in a whole wide range of cases, from complex asylum and human rights claims to private tier 1 investor type cases. The core of Greg's practice is public law. I've had the pleasure as well of working with him in a long-running judicial review, which we really hope we will succeed in at the end of the day. He's extremely experienced advocate in the tribunals and regularly instructed in his own right in the Court of Appeal. He does urgent removals and is very comfortable at taking on cases at short notice. Also, Greg writes of significant contributions to MacDonald immigration law and practice and the Butterworth Immigration Law Service, and he contributes to free movement and is a commentator in press and journals on immigration and refugee crisis. So he really is another great person to be hearing from today for those who are outside the immigration field and for those who are in it. So take it away, Greg.
Thanks very much, Sonali. I'm going to share my screen. I've got a PowerPoint as well. I just want to kind of welcome this opportunity to horrify criminal practitioners with the reality of immigration law. And what I'm going to talk a bit about is deportation and exile. And what I mean by that is the ongoing consequences of deportation for people who were born in or grew up in the country that they're being removed from, and why I think that's important for Article 8 purposes. So the point of the talk that I'm going to give is to give an overview of how deportation works in terms of Article 8, and sort of how we all ended up here with the case law the way it currently is. And I want to examine the position of young adults who've lived most of their lives in the UK and face deportation, and some of the qualitative differences between what deportation means for those people and what it means for other migrants. So first of all, not fit for purpose. That was an expression that John Reid used when he came into the Home Office in 2006 after Charles Clarke's defenestration following the foreign national prisoner scandal. What happened there was it turned out that a lot of people, some of whom had committed really serious offences, weren't being considered for deportation at the end of their criminal offences, and there was over 1,000 of them, and it was a huge story. And it was massively fanned by the right-wing press, and the Daily Mail had an absolute field day with it. I don't think it's an exaggeration to say that this story was a contribution to the change in government in 2010. It was massively, massively damaging to the Home Office, to the Labour Party, and to the lives of migrants, really, ever since. So the situation at that stage was that, as I said, people weren't being considered for deportation at the end of their criminal sentences. So you'd be somebody who had no leave to remain, no entitlement in the country at all, get to the end of a sentence for something really serious, and you just get out, which obviously really, really upset the right-wing press. Following that, a number of terrible things happened. So, for example, in the Lumba case in 2011, arose out of the fact that there was a secret policy, a secret blanket policy that prevented foreign national offenders from being released. But in addition to that, there were a series of really major legislative changes. So the UK Borders Act 2007 introduced automatic deportation, which Helen's already spoken a little bit about, and it introduced the idea that not only could you be detained pending deportation or pending removal, you could also be detained while they decided whether to deport you at all, possibly for an extended period. I'm going to give some examples later. The 2012 immigration rules, which, as well as like the destroying the lives of people who wanted to bring in their spouses, or people who want to be able to look after their aging parents, also defined when deportation would be proportionate for Article 8 in Article 8 terms, and it took a while to try and fix that in the Court of Appeal. But then, of course, the Immigration Act 2014 came in and introduced limitations on the rights of appeal to the tribunal in lots of instances, and also defines when deportation will be proportionate for Article 8, just like in the immigration rules, but this time now in primary legislation. Then we had the 2016 Immigration Act, which created the hostile environment and also introduced Theresa May's innovation that people should be deported first and have their appeals afterwards. All of this and everything I'm going to talk about in terms of the kind of catastrophic consequences for individuals facing deportation has been aimed at the tabloid spectre of the foreign criminal. Now, I went on the Daily Mail website today, so you wouldn't have to. It's a grim place, but I just wanted to see, are there any stories about foreign criminals? And of course there are, because it's a day with a Y in it. And there's another article about how easy it is for people to evade deportation, mostly because of people like me and Sonali and Helen, immigration lawyers who are apparently, I think the word was guzzling legal aid money. I think it was something like that. It was some kind of impression of a trough anyway. But those stories are still going on. And the impression you get if you look at the Mail website is that it's quite easy to it's quite easy to, feasting was the word, thanks Gillian, feasting we were. The impression you get if you look at the Daily Mail website or the Telegraph website, and actually sometimes the Mirror as well, is that it's very easy to win deportation cases. I distinctly remember a point when every single time I won a deportation case that was mentioned on Bailey, it would be in the paper 100% of the time. And the facts would be wildly misleading. But the fact that most of those cases fail would never make it into the paper. So if you read these papers, you'll be under the impression that it's a really, really easy to avoid deportation. That's absolutely not the case. The consequences of the current deportation regime, which has been harsher and harsher and harsher every couple of years, except for the 2017 to 2019 government when they didn't have a proper majority. It's always getting worse. It's always getting narrower. And there's a huge disconnect between the way people think the immigration and deportation system operates and how harsh and cruel it is in reality. So, who are these foreign criminals? Well, we've already had the definition from Helen from the 2007 Act. The 2002 Act, following the amendments made in the 2016 Act, define a foreign criminal as a person not a British citizen, convicted of an offence and has been sentenced to a period of imprisonment of at least 12 months. So that's the standard one you're used to, but also has been convicted of an offence that's caused serious harm. So if you kill somebody by accident and you are but it's nevertheless a crime, for example, in the kind of, I suppose, careless driving would be the classic. Even in circumstances where a judge considers that your culpability doesn't justify a sentence of 12 months, you could still be deported on the basis that your offence has caused serious harm. Or thirdly, is a persistent offender, and Helen talked a little bit about that. So who are these foreigners, these foreign criminals? Well, that would include somebody who's lived most of their life in the UK. That would include somebody who's lived most of their life, or even all of their life in the UK lawfully. You could still be a foreign criminal for the purposes of the 2002 Act, as long as you're not a citizen, which is why the PRCBC's work is so important and why Helen talked about that. And it would include someone born in the UK, and it includes someone whose offending is primarily when they were a child. Although it is worth saying it's an exception to automatic deportation that you were a child at the time of your conviction for a 12-month sentence deportation. So what happens if you're a foreign criminal? So you've got two guys that go and they rob a shop together, and one is you're both born in Croydon. One of them say both to Jamaican parents. Say one of them is registered as a citizen, one of them isn't. What happens? They both get to the end of their sentence. One of them is released, is under supervision from probation in the ordinary way. The other one will be detained. Almost always will be considered for deportation, and almost always, if you meet the deportation criteria, when I say almost always, I mean pretty much always, they will get a deportation order and they'll have to appeal it. That detention is in practice in prison. So what will happen is on the day they release, they'll be given, or the day before, they'll be given a piece of paper saying you're being detained for immigration reasons, and they're not going to be taken to the immigration removal centre under the service level agreement that the Home Office, the MOJ has with the Home Office. They will stay in prison, at least initially. They may stay in prison the entire time if there's somebody who has mental health issues. They might say, it's not an unusual thing for the Home Office to say, we are keeping you in prison rather than an immigration removal centre because you're mentally ill. Or they will say that you've, because of the kind of offences you've committed, we're going to keep you in prison because it's safer. The detention may be for a very lengthy period, particularly. So if you're somebody who came to the UK at a very young age, particularly in complicated circumstances, it might not be that straightforward to document you for removal to Somalia or wherever you've never been. And because of that, that can mean that you can stay in detention for a very long period indeed. So I've chosen a couple of case studies. They're both cases I did, and they're just ones I found particularly egregious. Vassallo was a case I did. This little old Italian man I represented. I mean, to be fair to him, he did commit a burglary every 3 years for 40 years. So, actually, that's not true. I think it was 50 years. A lot of his rap sheet was incredible. A lot of his old offences were like the Borstal Act and stuff I'd never heard of. But he came to the UK aged 4 in 1952. He'd been in the UK for longer than the Home Secretary who was trying to deport him. He was a repeat offender, but they were acquisitive offences. They were distraction burglaries, nasty enough. But he wasn't really a dangerous person to anyone. And he did also represent Britain in the International Over 65s Bodybuilding Championship. So he was really into that and hairdressing. And he's a really nice guy. The Home Office spent 4 years and went all the way to the Court of Appeal trying to deport him to Italy. Like, he didn't speak Italian. He didn't know any Italians. He'd only been to Italy once in the early 1970s. And he said he only went once because he didn't like it, didn't like the food. Nevertheless, the Home Office tried to deport him. And that's, I think, not something that you get if you were simply reading the tabloid about how deportation works. Sam Louis, a case I did quite recently. This is a guy who came to the UK aged 13 in 2003. The court found he was effectively abandoned by his family and ended up in care. So he was somebody who the British state, had responsibility for from quite a young age. No attempt was made to regularize his status for years. An application was finally made in 2007. But in 2009, he committed a robbery on a bus. Him and a bunch of guys went on a bus on Halloween and asked people for their mobile phones, intimidating them, which was, a serious enough offence. They got 18 months for it. And the Home Office decided to deport him, and he was considered for deportation. And then they spent 4 years going, well, we don't really know who this guy is. Never approached social services, didn't look at the application that he'd put in for settlement, which included his identity document. So 19th of May 2011, he transferred from prison to still prison, but now having been detained by a civil servant. The Home Office took 2 years to decide whether to deport him at all. He was in the end detained for 4.5 years, and by the time of his release, he'd spent 15% of his life in immigration detention. So that's what life is like for people who face deportation. That is what the reality is like. It's not the impression you get from the press, but the Home Office attitude to deportation is ever harsher. So what's the test for deportation of a foreign criminal? Now, when I say the test, I mean in Article 8 terms. Obviously, if you're trying to deport someone who's got a risk of persecution, the Refugee Convention comes into play, potentially Article 3. There are various other bases on which you could resist deportation. But generally, when you're talking about somebody who's born in the UK or grew up here facing deportation, you're talking about private and family life under Article 8. The old proportionality exercise, where the judge would just weigh up what they thought, is gone. And the Home Office didn't like that because they lost some of those cases, often for good reason. And you'll notice that the pattern of all of the changes to the immigration rules, the changes to the legislation, have all been to narrow the discretion of judges and narrow the discretion of the Home Office itself, again in response to press pressure. But as I've already alluded to, the press's view on how easy it is to deport somebody doesn't change when reality changes. You can't fight a publicity campaign with legislation, because the Sun doesn't report when somebody is successfully deported. The Sun doesn't report if a judge decides that somebody's deportation would in fact be the most appropriate thing to do. They only report the opposite. Section 117C of the 2002 Act is a critical provision, and that provides the deportation of foreign criminals is in the public interest, first of all. So that doesn't matter. So it doesn't matter if you've got kids. It doesn't matter if you're essential to your partner's life and your partner's somebody significantly disabled. The starting point is the deportation of criminals is in the public interest. The more serious the offence, the greater the public interest. In the case of somebody who's been sentenced to a period of imprisonment of 4 years or more, who's not been sentenced to, so if your sentence is under 4 years, exception 1 or 2 will mean that the public interest doesn't require deportation. Exception 1 is the most important for our purposes. Somebody has been lawfully resident in the United Kingdom for most of their life. So if you have been living in the UK for most of your life, but your parents never got around to sorting out your immigration status, then it doesn't count for the purpose of exception 1. Criterion B, socially and culturally integrated into the United Kingdom, and C, there would be very significant obstacles to integration. So if you're, for example, you come from Canada, and there's nothing that would stop you integrating into Canada apart from the fact that you've literally never been there, don't know anyone there, don't know any family there, you don't get in under section 1 either, unless there's some other particular obstacles to your integration. In the case of a foreign criminal who's been sentenced to a period of imprisonment of at least 4 years, so if you're over 4 years or right on the mark, which is the worst, the public interest requires your deportation unless there are very compelling circumstances over and above those described in the exceptions 1 and 2. So you not only need something of the order of exception 1 and 2, and exception 2 is to do with family life with partners, for example, and children, but you need something extra. So it's an incredibly stringent test. What does social and culturally integrated means? CA Nigeria, Leggett gave guidance on this. That was somebody who came to the UK age 1 and then committed a few offences around the age of 20, and the Home Office decided to deport him. So relevant social ties include relationships with friends and relatives, as well as ties formed through employment or other paid work, etc. But your social identity is not defined solely by those relationships, but a familiarity with, participation in the shared customs, traditions, practices, beliefs, values, linguistics, idioms, and local knowledge, which situate a person in a society or a social group and generate a sense of belonging. Like, for example, I had a guy who's being deported to St. Lucia, and I remember his girlfriend saying, well, he's never left the M25. You know, what's he going to do in St. Lucia? He's, you know, a pure London boy who's effectively being sent somewhere he'd never been. So that's what social and cultural integration means. Very significant obstacles to reintegration. What does reintegration mean? Well, it's a broad evaluative judgment as to whether a person will be enough of an insider in terms of understanding how life in the society is, and his life is carried on, and can participate in it to have a reasonable chance to accept it there and to operate on a day-to-day basis in that society. So what I think is missing from that kind of analysis, those looking at integration and looking at how integrated you are and how hard you'd find it to adjust, is the huge difference between deportation of a person who's born in or grew up in a country and a person who's a relatively recent arrival. So if you're born in London, or you arrived in London aged 3, and you're being removed to Mogadishu, obviously that's really problematic for a number of reasons. But it is effectively punishment by transportation or exile. It's like the thing they used to do when they hoarded people onto ships and sent them to Australia. It's essentially the same thing. And it's generally speaking, the consequence, like if you go back to the two guys with the Jamaican parents, his example I gave, the fact that he's going to be deported, or in theory, at least, to Jamaica is a far more serious punishment than the criminal sanction he's just received, and it's then more or less any criminal sanction. It's not just being taken away from your family, your friends, but it's from severing you from everything you know, from your entire environment, from the whole culture that you're familiar with. You know, going back to my example, Mr. Vassallo doesn't speak Italian, you know, doesn't like Italy, you know, hasn't been in 40 years. Sending someone like that to where they're in theory from is a really serious thing to do. It's something a lot of people won't recover from. Another point worth making is it's effectively the exportation of criminals. So, and this has been really problematic. So, for example, the DRC at one stage was just re-jailing people who were being removed on the basis that they were criminals, because the DRC didn't want criminals. Mogadishu at one stage was that the president there was a presidential election happening, and the Somali authorities refused to take any more deportees from Mogadishu, because the people of Mogadishu kind of looked around and said, well, do we necessarily want these kids who arrived very young in the UK, weren't looked after properly by the state, and have now become criminals? And that too, Helen referred to the homegrown criminal, and that's something that the courts have complained about, people talking about homegrown criminals. But homegrown criminals are a thing. You know, if you arrive here aged 3, and at age 20 you're a bank robber, you know, that's not Belgium's fault. Like, that's the UK's fault. Like, the state that has failed the child who became the criminal is not the state to which that child is being returned as a damaged adult in many cases. Not just a damaged adult, but an adult who's going to find it very hard to readjust. So Lord Justice Sedley held in HK Turkey that the number of years a potential deportee has been here is always relevant, but what's likely to be more relevant is the age at which those years began to run. And he says ultimately the difference, 15 years spent here as an adult are not the same as 15 years spent as a child. The difference between the two may amount to the difference between enforced return and exile, and that's what we're talking about. And that approach has been disapproved of in Benbuga, which Helen also referred to. And none of those criteria I've taken to really take account of the huge difference between a person being deported and the person being exiled, because they are massive consequences. Strasbourg is slightly better. Bultif in Switzerland, the European Court of Human Rights, said that you need to take into account the nature and seriousness of the offence, the duration of their stay, the time that's elapsed the offences, nationalities of people involved, applicant's family situation, the length of the marriage, etc. If you're married, whether the spouse knew about the offence at the time she entered the relationship, and children, etc. That wasn't a case involving somebody who'd been for a very long time in the state. But in Maslov against Austria, the European Court of Human Rights gave slightly more robust guidance. And it said that the court considered that for a settled migrant who's lawfully spent all or the major part of his or her childhood and youth in the host country, very serious reasons are required to justify expulsion. All the more so if the person committed the offence's underlying expulsion measure as a juvenile. And Helen already spoke about that. But a person is not a settled migrant for Malazan purposes unless they were here lawfully. So if you were brought over at age 3 and nobody ever regularized your status, then you were essentially being punished for that as an adult. So is it double punishment when you go to deport somebody who is who's already served a sentence? Well, apparently not. The Court of Appeal says that automatic deportation is not a penalty for the purposes of Article 7. CG against Bulgaria says that the protections of Article 7, which is no punishment at law, without law, don't apply to deportation decisions at all. The court in Unir against Netherlands says that deportation on top of a criminal sentence is not a double punishment, either for the purposes of Article 4, Protocol 7, or more generally. I mean, it's an incredible statement to me that you could say that deportation on top of a criminal sentence is not a double punishment. I mean, they put you in a detention center for 4 years and then they take you away from your entire family and put you in a different country. If that's not a punishment, I don't know what is. So what do we have to look forward to in the future? Well, there's some slightly better case law at the level of the Court of Appeal. Most Court of Appeal authority isn't quite so helpful. But this is something I think that we will need to push more and more because, as I said earlier on, this is a PR campaign. This is a publicity campaign. The right-wing papers are going to continually say that it's easy for criminals to stay in the UK. Ever since the 2006 scandal, it's been day after day, case after case, publicized, often with wildly misleading facts. And I think you have to fight this kind of disinformation with publicity, with information. In 2020, Detention Action carried out a poll that found that nearly 8 in 10 people agreed that people who came to the UK as children should not be subject to automatic deportation. Not only that, but in that same poll, Detention Action put to people what the law actually says as regards deportation and asked if they agreed with it, and most of them didn't. But many of them will read the Daily Mail and then will go and vote for parties who are committed to implementing the Daily Mail's agenda. And we know that Priti Patel is planning to make appealing even more difficult and is planning to do something about troublesome lawyers like me, Sonali, and Helen, and indeed Julian Stern. That's all I wanted to say. If there's anything anyone wants to ask about, I'm happy to speak about that in the chat or at the end.
Great, thanks very much, Greg. Yes, questions in the Q&A, ideally, but thanks very much. And yes, from one troublesome lawyer to perhaps a troublesome academic, I don't know. Dr. Tim Bateman, academic at University of Bedfordshire and Children and Young People's Centre for Justice Associate, as I said at the introduction. Just to tell you that Tim's main area of research and teaching interests are youth crime and youth justice. He's been at the University of Bedfordshire since 2010 and previously worked as a policy officer for a national charity and a youth justice social worker in a number of local authorities. Between 2015 and 2017, he was seconded full-time to the Office of the Children's Commissioner for England as the Principal Policy Officer in Youth Justice. He's currently the chair of the National Association for Youth Justice, the Deputy Director of the Vauxhall Centre for the Study of Crime, the co-editor for Safe Communities Journal, and on the editorial board of the Youth Justice Journal and the Child and Family Law Quarterly. And he also has very recently authored the State of Youth Justice 2020. And so obviously that demonstrates that Tim is the absolute expert that we want to hear from and need to hear from next. So thank you very much, Tim, for sparing the time and coming to talk to us.
Oh, thanks, Sonali, for that kind introduction, even though I probably wrote most of it myself. I need to get my excuses out of the way early on. So as the introduction will have made clear, I'm not a lawyer. And to be frank, the only thing I know about the legal provisions in relation to naturalisation and deportation are the two presentations that I've heard so far this evening. So I'm going to want to steer clear as far as I can from what for me is a pretty fuzzy area. But I do hope to be able to offer at least a couple of thoughts that might have some relevance to the logic of the decision-making process in relation to deportation. And I want to talk in particular about two distinct but closely interrelated ideas. First, the notion of what I'm going to call for tonight's purposes, the idea of growing out of crime. and then some reflections on why that happens. And second, I want to look a little bit at the context in which childhood offending tends to occur, because that context, in my view, provides a framework for how we should understand and how we should respond to youth crime. So moving on to the first of those issues, it's a well-evidenced fact that the vast majority of children grow out of crime. And what we mean by that is that they leave their offending behind them as they make the transition to adulthood. Criminologists are an argumentative bunch and don't agree about very much, but one point of consensus is that this relationship between age and crime is a consistent one. And as far as we can tell, a similar relationship pertains across historical time and across culture, albeit with some differences of detail. So Gottfredson and Hershey, for instance, who are two of the best known criminologists of the last century, note that the empirical fact of a decline in the crime rate with age is beyond dispute. This decline is generally referred to as something called the age crime curve. And I'm going to try and show you what that looks like. So I've got two slides only, but I'll try and share my screen and get those up in front of you. Okay, so this is an example of the age crime curve. It's from a paper by Susan McVie, who's one of the co-directors of the Edinburgh Study of Youth Transitions in Crime. And it's based on self-reporting offending. So it's based upon what people tell the researchers. And you can see that the general contours are pretty dramatic. So the bottom axis is age in years, and then the left-hand side axis is the rate of offending per 10,000 population. And what the graph shows, if we look at the top line, which relates to males, is that there is an extremely sharp escalation in the rate of offending among the teenage population. But once you get to the peak, which occurs at around 17, 18, 19, there is then a fairly rapid and consistent decline, which continues throughout the life course. And if everyone in the population was aged 60 or over, you could definitely leave your front door open when you went out and still be fairly confident that most of your belongings would be there when you come back. For females, the pattern is broadly the same, but more muted. So the level of offending does rise during the teenage years, but to a much lower extent. And the fall is correspondingly less pronounced too. So that's one kind of indication of the age crime curve. I don't seem to be able to get the other one. That's... Okay. So this is another example, and this is from the Home Office. It's a bit old. The reason for that being is the Ministry of Justice don't publish data in quite the same way, so you can't produce this kind of graphic any longer. But this shows detected offending. In other words, crimes that have resulted in a conviction or a caution. And you can see that the pattern of a sharp rise during teenage years and then a subsequent sharp fall is also reflected among those who come into contact with the criminal justice system. So it's what people tell us about their behaviour, and it's also what happens within the youth justice, within the criminal justice system. The age crime curve is something which is fairly uncontroversial. It's incontrovertible. It just simply happens. The consistency of the curve, of course, does raise the question about why it happens. Why do children grow out of crime? And there are two types of answers which are typically given to that question. And the first is relates to maturation. Teenagers, those of you who have kids in the relevant age bracket will know, are different from adults. They are frequently impulsive, they're natural risk takers. If you doubt that, go and look at the age demographic of those who are on the scary rides at Thorpe Park. It's not people my age, I can assure you. They find it hard to defer gratification. If they want something, they want it now, not next week. Their future orientation doesn't extend very far. When I have discussions with most of my colleagues, pensions inevitably come up. That doesn't happen with teenagers chat in the pub. They don't think through consequences, and they're susceptible to the influence of peers, and much youth crime occurs in that kind of setting. It occurs with peer groups. But all of these things change very rapidly as teenagers mature psychologically and emotionally. They simply start to think and behave in different ways. That maturation process is reinforced and closely intertwined with the second explanatory factor, and that is socio-structural change. So as children make the transition to adulthood, their role in the world changes accordingly. They move from the world of school to the world of employment or higher education. There is a shift in their nature of personal relationships, with an increasing number of people becoming engaged in longer term relationships. There is greater independence from family and peers, and a corresponding need for a stable income. And for many, particularly but not exclusively young women, there are greater expectations in relation to taking on caring responsibilities. And so these new roles are associated with different expectations of behaviour. And from a practical perspective, they simply allow young adults less time for hanging around the streets with groups of friends, and the environment in which they inevitably get involved in activities which can bring them to the attention of the police. So these shifts in social roles, social expectations, in combination with the emotional and psychological changes that we see during the move from adolescence to young adulthood, explain why the age crime curve is so persistent. And this persistence, I think, is relevant to any potential rationale for decisions in relation to naturalisation and deportation, since childhood offending, however persistent or serious, is no indication whatsoever that the emerging adult will pose a risk of further lawbreaking. The adult and the child are, from a psychological and social perspective, almost literally different people, certainly so far as offending is concerned. So the logic of deporting somebody at a point where they're transitioning to adulthood for behaviour committed as a child is a deeply flawed logic, I would argue. The second area I want to explore is the context in which youth crime occurs. There's fairly strong evidence that nearly all of us engage in activity that is contrary to the criminal law when we're children, but it's equally evident that some do so more often than others, and there's a very clear and powerful relationship between higher levels of youth crime and economic and social disadvantage. It's important to note that even from the perspective of those who are the most persistent, crime is a relatively marginal activity in children's day-to-day lives. Their main focus is on getting through the day, on relieving boredom, on having fun, attempting to identify from a range of limited options how they're going to survive over the coming period. Criminal activity where it occurs isn't really seen as such in those contexts. It's simply part and parcel of a normalized response to the environments in which such children grow up. Those environments are characterized by deprivation, substandard housing, racism, poor education and health provision, and next to no youth facilities. Now, this isn't just to point out a link between crime and social inequality, although such a link is undeniable. It's rather to highlight that persistent youth offending takes place in and as a result of a context over which, by comparison with adults, children have almost no control. They don't decide to stay within those environments. They don't decide to live in those communities. That is determined by adults and agents of the state. It's not determined by those children. One of the facets of growing out of crime is that children develop increased agency over the circumstances in which they determine they want to live. And they can increasingly make decisions as they mature and become more socially independent. And they start to have some choices, albeit constrained, over their environment. So holding children responsible for their behaviour that is largely a byproduct of predetermined circumstances through, for instance, deportation, is irrational. It retrospectively holds children to account for the conditions in which they were raised. And it also, by implication, excuses authorities who had neglected to provide the necessary commitments and resources to tackle social inequality, and it absolves those agencies who failed to provide requisite levels of support to children who suffer as a consequence. Just to sum up, I wanted to try and tie one or two of those themes together. I mentioned that the adoption of new social roles is critical to growing out of crime. And I also pointed out that the increasing role of agency in allowing children, as they make their transition to adulthood, to exercise choice is over their destiny is also significant in the way that their futures develop. And these two things, it seems to me, are clearly linked, since the extent that agency will develop in a positive direction is closely associated with the prospects that the child sees for their adult future. The threat of deportation in this context closes off the possibility of growing into these new pro-social adult roles, and thereby inhibits children's potentially positive self-narratives about the kind of adult they would like to be, making it less likely that they will be empowered to leave their past behind them. Restricting those possibilities not only fails to take account of the natural tendency to grow out of crime, paradoxically, it also inhibits and disrupts that natural process, increasing the potential for continued offending into adulthood. That's it.
Thank you very much, Tim. That was really fascinating. So it's so interesting for someone who's been practicing in immigration and law for 30 years. And we see obviously a lot of children and adults at the sort of sharp end of deportation, but to see that the impact of that set against that, so that evaluation of how their offending is taking place really makes a lot of sense. And it'd be amazing if policymakers could recognise that the future risk of reoffending is a really important factor, and that for many, if not most children, they will have effectively grow out for the reasons that you've said. It couldn't be more important. We've got a number of questions in the Q&A. I think everyone who put them in the chat has moved them over to the Q&A. I wanted to ask the first question. One of the questions I think is quite interesting, which is from Joe Mandava, which is what the criminal age of responsibility in Scotland is 12, but the good character requirement for registration for children is 10. How does that square up? I just wondered whether you had anyone had any thoughts on that. That's perhaps for Helen to think about, because it does demonstrate an anomaly. And I just also wanted to mention that the Rehabilitation of Offenders Act expressly doesn't apply in immigration and in immigration cases following an amendment that was brought about in LASPO. So and again, criminal practitioners may or may not know that, but that's in my case.
Oh, it stopped. Oh, it's because Sonali's been put on mute.
I will let someone answer the question about the 10-12, and I will mute myself.
So perhaps I can come back on that. I know Greg's got some good thoughts as well. I mean, I suppose one overall point is that the good character guidance is not limited to criminality. It's very broadly defined. It would be quite interesting, this is not my suggestion, it's Greg's suggestion actually, so I'll let him pick up on it, to consider a case where somebody in Scotland was refused citizenship based on something, they'd, well, I guess if they were under 12, they wouldn't have been convicted, but conduct, or perhaps criminal conduct not leading to a conviction if they were aged 11. It's a very interesting question. It sort of emphasises just how broadly defined the good character guidance is. I should also say that the context of my talk was about naturalisation applications. That character guidance applies not only to naturalisation applications, but all children's registration applications. It doesn't apply to certain categories of case where you're entitled to citizenship, but it applies to all children's applications as long as the children are over. Yeah.
So, do you want to add to that?
Yeah, it would be an interesting point, but I don't think it could ever happen because, if you well, I suppose conceivably commit a crime in England, age 10 or 11, and then in Scotland, then be in Scotland when you make your application. But then I don't think, I think it'd be very difficult. It would be very difficult to imagine circumstances in which it will arise. So, in practice, I don't think it'll make much difference.
I hope the background noise is gone. I think it was a sort of aeroplane. No, it hasn't gone.
It hasn't, no. Sorry.
Okay. Sorry.
I'll just maybe take over the questions in the Q&A, which I've lost for a moment. So thank you, Joe, for that question. I think what it does raise is just how low the age of criminal responsibility is in England and Wales, and given what we know from Tim about the factors that are affecting children that cause them to commit criminal offences, even 12 is pretty low, and it's totally out of step with the rest of Europe. For example, we have one of the lowest stages of criminal responsibility in the world, and definitely in Europe. So I'm going to look here at the questions. So there was a question from Vijay Sharma about, are victims of trafficking protected from deportation? Will a positive conclusive grounds decision as a victim of trafficking have an effect of revocation of a deportation order? So perhaps I could turn to, well, Helen or Greg, whoever would like to answer.
I think there's basically two answers to it. It depends. So if, for example, you're being deported because you have been found in a cannabis factory and you were convicted on that basis, and you were then able to show that you were in fact a victim of trafficking, you should be trying to overturn the criminal conviction, and if that happens, then you're not going to be deported. But otherwise, a positive conclusive grounds decision isn't a complete bar to deportation. You bring an appeal. You can only appeal on the basis that your removal would breach either the Human Rights Act or the Geneva Convention, effectively. So you are, the fact that you're a victim of trafficking could be relevant insofar as you're still at risk of trafficking. So that might be relevant to Refugee Convention grounds, it might be relevant to Article 3, and it might be relevant to your Article 8 case. But in itself, a trafficking positive conclusive grounds decision isn't, so far as I'm aware, a complete barrier to deportation.
But can we just turn to Helen? I think you have a case that touches upon these issues.
Yes, so like Greg said, if the original offending occurred in the context of the exploitation, then potentially there were grounds to overturn your conviction. And I have a case where it looks like those are the circumstances. So we have a very complex human rights. Well, it's actually an application to revoke a deportation order, and the person concerned was subject to sexual exploitation and committed drug dealing offences, which attracted a lot in the, because she was exploited. So the strategy that we've decided we're going to take is to ask the tribunal to adjourn the case until that whole process has gone through, because it's a fairly clear-cut case. Whether they'll agree to such a long adjournment is a different matter. But as Greg said, whilst there's no statutory bar, you're still liable to deportation if you were a trafficking victim. In most trafficking cases, there will be an argument that removal would breach Article 8 or sometimes Article 3 rights, or often that there'd be a risk of re-trafficking, a human right and a refugee convention claim. So the trafficking convention and the human rights convention and the refugee convention would all come together in the deportation appeal. So I guess the short answer is, not necessarily barred from deportation at all, but there are various ways of getting out of it.
It is worth sharing with the audience that there has been a recent case in a criminal context of Bracani before the Court of Appeal, a case heard by the Lord Chief Justice, which overturned an earlier case of the High Court, which was effectively saying in criminal cases you could accept a positive conclusive grounds decision as expert evidence, and that decision sadly has been overturned. So the challenges in getting your status as a victim of trafficking both recognised and overturning a conviction might be considerable, but that seems to be that's the advice being given, that would be if you could do that first, rather than it being a bar to deportation in the immigration proceedings. But it is becoming increasingly challenging to get that status recognised and to raise the Section 45 modern slavery defence, which generally is the way in which you can avoid convictions. So I believe that I believe that might, I think there will be a hope that Bracani decision may be revisited, but that's the law as it stands at the moment. I'm now going to change topic a bit because we've got a question which is interesting from Robin Kerrison, and this is, I think, best posed to Tim. So the question is, it would be interesting to know how the experience of incarceration impacts the curve in terms of the curve of desistance that we've seen with age. The assumption that Robin is making is it increases the likelihood of later offending, but does the data bear that out?
Okay, I think the logic of the explanation of the age crime curve that I gave would suggest that the imprisonment would have that effect because it would constitute significant disruption to the natural process. It makes it much harder for children to make the transition socially in terms of moving from the world of school to the world of work. It also has a substantial damaging impact on the way they see themselves. There's a real risk of children who are imprisoned developing an identity which sees themselves as being offenders in the longer term. So there is a real potential in terms of the way that incarceration works for it to interfere with that natural process of desistance. The data does bear it out to a degree, but it's slightly complicated. So what we know is that 12 months reoffending rates are higher for child imprisonment than for any other kind of sentence which are given to children. Also, incidentally, substantially higher for adults who get imprisoned. Their reoffending rates are lower than for children who are in prison. And of course, that fits with the age crime curve thesis, because you'd expect children are still at the point where they haven't yet reached the peak age, so you'd expect it to be higher. But it's for people who don't know, I mean, it's shockingly high. So for sentences or 6 months of less, the rate of reconviction within 12 months has been more than 70% for every year over the last decade. So that is substantial. It's very, very high indeed. However, it's also the case that you can't easily compare reoffending rates for imprisonment with, say, reoffending rates for a community sentence, because the courts would say, and there's an element of truth in it, that those children who get custody are committing more serious offences and are more persistent offenders. So it's not a like-for-like comparison. Where we do have research which has tried to control for persistent offending and for seriousness of the offence, which then limits it to a relatively small research sample population, those who are on the cusp of custody and either do get custody or don't, then that research has suggested that imprisonment at that age increases the risk of offending by something like between 6 and 12%.
Thank you, Tim. And we have a question from Tariq Nawaz. Apologies if I've mispronounced your name. A young person, now 22, came here at the age of 5, committed a single offence at the age of 20. It was a knife offence and drugs, and he received a 2.5-year sentence. He's now been released, but he has been served with a notice to deport. Greg, would you like to answer that?
Sure. I mean, those facts don't say to me that he's doomed. I think that sounds like a very winnable deport, but you'd want to, deportation cases are very hard, and so it'll involve. I'd want somebody experienced doing it, solicitor-wise. I mean, and you'd want to get good evidence, really good evidence of integration, his family, friends, and I would tend to try and get an expert report into risk of reoffending in those kind of circumstances as well. But in principle, that looks to me like a very winnable case.
Tariq, it looks like you might have your lawyer for that case in the room, so leave you to get in touch. Thank you so much for that, Greg. Nia has asked, what's the position where a child is released under investigation without charge? This means that the investigation could continue for months, maybe years, but hangs over the child's head, and will be taken into consideration in a naturalisation application. I'm assuming you're meaning that this is really common practice. It's really problematic in terms of the criminal justice system, causing huge delays. And when we know there's delays from the pandemic, some children are waiting several years, and adults, of course, but in a child's life, that's considerably a bigger proportion of their life. Do you mean when I'm assuming you mean when the investigation is ongoing? Helen or Greg, have you got any comment on when ongoing investigations might impact a naturalisation application?
Yeah, I mean, I've just had another look at the guide. I mean, if the child were released without charge, and that were the only character issue in their background, then although the guidance is very widely drafted, it wouldn't necessarily capture that. I mean, having looked at it, and bearing in mind that it has to be flexible in the case of children, it would be surprising, draconian as that guidance is, for that to be taken into account. So the sorts of conduct, non-criminal conduct, that are listed in the guidance include things like financial soundness, penalty charge notices, and so on, and ongoing investigation. It would depend on the circumstances, of course. In the case of an adult where there were very serious allegations which didn't result in a criminal conviction, that would be one thing, but I would be surprised if that would itself be a bar to naturalisation or registration.
We have one more question, which I would really like to come to, and I'm conscious of time, but I think it's worth making the comment at this stage that it's fantastic to hear about the work of the project for the registration of children as British citizens, but picking up upon, and you know, obviously that the suggestion there is, even if there is an ongoing investigation, don't hold back, put in your application for naturalisation. One of the concerns raised by Tim in his presentation is that authorities are failing children in not meeting their duties. One of those would be that if a child was a looked after child, it would be the responsibility of the local authority to regularise their immigration status. And so if you are, for example, a criminal lawyer working with a child who hopefully you've managed to avoid getting a criminal record, you would want to try and give them advice that if they do have, if they don't have settled immigration status, that doing so while they're still a child, before they're 18, has huge advantages. And if they can acquire citizenship, that clearly is the biggest protection against these very draconian policies and legislation. So turning now to Julian Stern, who asked the question, does anyone have a view about challenging the lack of automatic access to legal advice for children facing deportation decisions? Guidance says only an appropriate adult needs to be present. And this is something that has been of concern of mine for some time, that children get a note through their door in somewhere like Feltham telling them they're facing deportation. The only lawyer they know is a criminal lawyer. The timeframes are tight. And the criminal lawyer may just not know how to get access to an immigration lawyer in the timeframes available. So, Greg, perhaps you'd like to come in here on challenging the lack of the absence of automatic access to legal advice.
Yeah, I mean, I think that's right for a challenge. There's a decision from Mr. Justice Swift on the lack of appropriate access to immigration advice for people in prisons compared to people in immigration removal centres, which is a big problem from a few months ago. And it's a really good judgment. And I think the arguments in that would apply a fortiori in the case of a child. I think that's a really good argument to run. I think it's a good case.
What we'll do is we'll get Amy to circulate that case in the follow-up email, because that's obviously one for people to know about. But I'm going to hand back to Sonali, who I understand has got rid of her aircraft interference. And thank you so much.
Well, I'm not sure you really need me, but thank you for taking over there. And I'm back on a different device. Most apologies for that. I think that actually, you may need to go back, because now on this device, I've logged in that I can't see the questions and answers. So
I think we've got to the end of the questions. I think
that's well, just as well, perhaps.
Brilliant question that has been posed about access to legal advice. Also, watch this space, because we're hopeful, working in the criminal justice setting, that there's going to be there's discussions about the push towards automatic legal advice at the police station, and that might be something that could also be compelling in an immigration context if that does take place.
I mean, what I would say just about that is that when the case about denial of legal aid, Godana Vicieni, was in the Court of Appeal, that was brought on the basis of a challenge on the basis of the procedural obligations under Article 8 ECHR. So the similar provisions or similar sort of structure of argument would apply here if you've got a cohort of children who are facing or at risk of deportation, who can't access appropriate legal advice in a way that's designed for them if they're in a detention setting or otherwise. And so certainly it seems to me that there is an opportunity to bring that challenge, or to develop that challenge. There's, the state is required to even for foreign national children, is required to have in place best interest considerations, and how those are going to be elicited. So there's a tussle as to how far positive obligations go in respect of Section 55 in this context. But I do think that you've got an Article 8 for Article 14, Section 55, access to legal advice challenge there. So I don't know if there are any other questions, Kate, that you can see.
No, I think we've answered them all. Robin just came back in to make the observation that Tim's comments about the high rates of reoffending for children who receive custodial sentences is yet another argument for alternatives to custodial sentencing for children, which I would also agree with.
One thought that's occurred to me during the course of particularly listening to Tim and Helen and Greg about that we define obviously foreign national offenders as anyone who isn't British, but there's a question about compatibility of that statutory scheme. If it defines everybody, including those who were born here but are not British, came here at the age of 1, like CI Nigeria, like my client who I'm representing at the moment. So, question about compatibility, and I would just say there's apparently a series of cases that are going to Strasbourg that are being communicated recently on the statutory scheme, the 117C scheme that both Helen and Greg referred to. So there it is. I don't know what all the facts of those cases are, but it would hope that there was one that was a young person who'd come at a young age, so that they could have the Strasbourg court could look at that question. But anyway, I think that brings us very neatly, I think, to the end of the session. So I've apologies for my end about whatever it was, aircraft or aircon, or I don't know what it was, for connection problems. But a really big thank you, obviously to all the Garden Court participants here, but particularly to Tim for giving up your time for coming here. It was really absolutely eye-opening for us, and it's always that case when we practitioners and academics come together that we get some real sort of synergy and the development of ideas. So that's absolutely brilliantly important. Thank you to everyone who attended, and I really hope that we can speak again about this. If you have cases or ideas or what issues you want to discuss, I'm sure the panelists within their ability will respond outside or offline. But thank you so much for coming, and the slides will be circulated, and we'll send around that case that Kate mentioned. So I hope that's everything for everybody. Thank you very much.
Thanks, folks.